When we step into a courtroom, we expect one thing above all else: a fair judge who stands above the conflict, not inside of it. Today, we're going to break down a question that comes up more often than you'd think. Why can't a judge practice law from the bench? And what does it actually mean when the law says a judge must stay neutral? Let's walk through it with clarity, with structure, and with the steady hand that the law deserves. First, let's ground ourselves. Practicing law isn't just arguing in court. It includes giving legal advice, drafting documents, helping someone choose legal strategies, or acting as someone's representative in a legal matter. Under the ABA's definition, the practice of law is the application of legal judgment to another person's situation. That matters because the moment a judge starts helping one party, they stop being a judge and start being a lawyer. Every judicial conduct code in the United States says the same thing: a judge shall not practice law. It doesn't get clearer than that. Federal judges follow this rule. State judges follow this rule. Ethics committees reinforce this rule. The only exceptions are narrow. A judge can represent themselves, and they can give limited, unpaid legal advice to immediate family, but never appear as their lawyer in any forum. So when a judge gives legal coaching from the bench, they're breaking the very rules that define their profession. But this isn't just about ethics rules. This is about the Constitution itself. The Supreme Court has been unwavering. Every person is entitled to a neutral, impartial decision-maker. Cases like Toomey v. Ohio, in re Murchison, Offutt, and Caperton all make the same point. A judge cannot be both advocate and adjudicator, not even in appearance. When a judge guides one party, when they advise, rewrite, or strategize, they tilt the scales that they're supposed to hold evenly. And constitutionally, that destroys due process. Let's make this real. A judge practices law from the bench when they tell a party which claims they should file, rewrite pleadings for one side, suggest legal strategies, pressure one side toward a specific defense or remedy, or step into the role of prosecutor or defense counsel. These aren't neutral judicial acts. These are acts of advocacy. The judge has crossed the line. Judicial discipline committees treat this as serious misconduct. Why? Because a judge who becomes an advocate is now wearing two hats, and that makes justice impossible. Judges have been removed, sanctioned, and even disbarred for it. And appellate courts overturn judgments when the judge stops being neutral. This isn't academic. This is structural. This is foundational. The courtroom only works when the judge stays above the fray, not inside it. Now let's keep this balanced. Judges can explain rights, procedures, how hearings work, what the law requires from both sides. They can ask clarifying questions. They can keep the process orderly. But what they cannot do, what they must not do, is give legal advice or strategy to a party. That's the lawyer's job. The judge's job is something different, to remain the impartial guardian of the process. So here's the truth, grounded in ethics, law, and the Constitution. Judges cannot practice law. Judges cannot act as counsel. Judges cannot coach, advise, or strategize for either side. Because the moment they do, the courtroom stops being fair, and justice, true justice, loses its foundation. A judge must be neutral, not an advisor, not an advocate, not a strategist, just the judge. That's what protects all of us. That's what gives the judicial system its integrity. And that's why the law draws this line so clearly. At the end of the day, the authority of the bench comes from trust. The trust that the judge stands apart, steady and impartial. The law protects that neutrality for a reason. Because without it, the courtroom isn't a place of justice. It's just another argument. And that's not what the Constitution promises us.